and good morning and welcome for the team from News on the Block. We are delighted to be bringing you a series of knowledge banks this February. The first session, Residential Fire Safety Update, is a topic which is on everybody's lips, and we are extremely lucky that Barrister Justin Bates from Landmark Chambers has agreed to join us. A man with his finger on the pulse, Justin has worked alongside the Law Commission to assist with leasehold reform, so is well placed to assist with this topic. He's going to begin with the presentation, but we'll be answering questions throughout, so please submit any questions you have using the Q&A tab at the bottom of your screen in the centre. So without further ado, I'm going to hand directly over to Justin, who will begin with his presentation. Justin, how are you today?
I'm here to work everything in the middle of my screen, and I have learnt that I should have shaved this morning.
I think you look okay. You're very possible.
Right, how do I get my slides up? Do I have to share screen?
If you do share screen, and I'm going to stop my video, and you can have the whole platform to yourself.
You say that it says host disabled participant screen sharing. This is what always happens at the beginning of webinars. We discover things have gone wrong.
I'm sure Vicky is on it at the other side to share that with you. Vicky, are you there? Have you managed to?
Yes, that should be working now. Apologies.
Do you want to give it a go now?
Right. Okay. Now I have to share my
presentation.
Yeah, hang on. Next bit is my fault because it's not open. There you go.
That's because we were chatting beforehand.
It was. This we spent a lot of time
we were shooting the breeze earlier about what we've all been doing in lockdown.
There we go. Let's make that.
Fabulous. Okay, Justin, over to you.
There we go. Right, it's me. Excellent. Well, thank you very much. Right, thank you everyone for dialing in for this. This is one of the big issues, probably the biggest issue in not just residential leasehold management, but I would say housing law and policy at the moment. And it's a pretty depressing issue. I was having a quick look at the attendee list as you're all joining in. Most of you I know are going to know, you're going to know about various funds and the various difficulties that arise. Most of you are on the landlord side, so you're going through the process of seeking money from these funds at the moment. And I slightly doubt that I'll be able to give you very much new material or update. I will try and make this as interesting as possible, but this is not a topic that lends itself to light-hearted discussion or, I'm afraid, to cheerful developments. I will pick questions at the end if that's all right, primarily because I can't see questions as they come in, given how my screen sharing has worked. So if I try and pick those up at the end, that's probably the best way to do it. And yeah, let's see what we're going to try and cover in the next 30-40 minutes or so. I want to talk a little bit about the Building Safety Fund, well, probably a lot about the Building Safety Fund, because that's really the primary source of funding to try and get buildings across England made safe. I want to talk a little bit about the Waking Watch Fund, which opened yesterday. The rather misnamed Waking Watch Fund, because of course it can't fund waking watches, it only funds alarms. And then I want to spend some time talking about developments in Parliament. There was a debate last night, you may have followed, where Labour put down a motion calling for the government to, among other things, forward fund the cost of all remedial works and then look at recovering later. That motion passed by 263 votes to 0. That does not mean, I am afraid, that the government has changed its position. The government abstained on the vote, so it's a slightly misleading vote to have there. But I want to talk a little bit about the parliamentary developments, because I think that's where the most interesting bits of all this are, and all that to do in, say, 30 to 40 minutes. So let's see where we go. Right, Building Safety Fund. I want to tell you a little bit about what it is, which I'm sure you all know. General eligibility requirements. I want to talk about timeline and take-up, because there's a concern in there, and I want to talk about apparent difficulties. Particularly, I want to flag up a concern for anyone here who acts for or advises housing associations or local authorities, because there's a real poison pill for social landlords in the Building Safety Fund, which is not getting anything like the attention it needs. And then let's talk a little bit about the practical implications of how you use your building safety funding. What happens if you don't get any funding? If you do get it, how do you use it? And then a question that people are throwing at me an awful lot, for obviously won't tell you the real answer, because if I did, stop paying me for it. How does Section 20 consultation and dispensation work in these situations? So the Building Safety Fund was the second of the government's funding responses to the events coming out of Grenfell Tower. It isn't the ACM fund, which is the first one. So as you all know, following Grenfell Tower, the government produced a fund called the ACM fund, which was designed to get aluminium composite material off buildings and to pay for recladding works, etc. The ACM fund has been broadly successful, depending on your definition of success. There isn't really enough money in it. It's had much more impact in the social sector than in the private sector, but broadly, we are making slow progress towards remediating ACM across this country. And the ACM fund was effectively the model for what became the more important fund, which is the Building Safety Fund. Because the problem with the ACM fund is, as its name suggests, it was limited to aluminium composite materials. And as everyone in this call knows, ACM is not the only or indeed the primary problem with building safety in this country. The reality is that we are looking at many decades of poor building practice, poor standards, poor regulatory oversight, and we have buildings up and down England of a variety of heights where there are fire safety problems, which range from things simply not being built in accordance with the plans and nobody having noticed, which include things being on buildings that, depending upon who you believe, either were or were not legal even at the time they were done. So things like HPL cladding, the cladding on wood decking on balconies, etc. And the one that particularly causes the most difficulty, at least to my mind, is the problem of lack of cavity breaks, or where there are cavity breaks in buildings, they're not functioning as cavity breaks because there's builders' rubbish left in them, so that the fire can spread. Problem throughout England and Wales. I'm not going to talk so much about Wales. I'm definitely not going to talk about Scotland, although Scotland seems to have a similar problem, which is just beginning to come to attention there. There was some interesting stuff coming out of Glasgow over last weekend. The estimate is that to make all buildings safe across England and Wales, you're probably looking at 15 to 18 billion pounds. The Building Safety Fund is a step towards, a very small step towards meeting those problems of fire safety in England. Firstly, though, it's a limited fund. It's only £1 billion. And it was supposed to be only for the current financial year. As many of you will know, if you've got applications in the fund, that's slightly been fudged now. The applications had to all be done by the end of last year, but you're allowed to get the funding, even if the work isn't going to start until the first part of the next financial year. It's limited to buildings of 18 metres and above, and that's been particularly controversial for two reasons. One is, whenever you have a cut-off threshold like that, you inevitably get hard cases that are outside of the cut-off threshold, and it's hard to see why they should be treated differently. The second is, there's no necessary correlation between height and risk. A point that was being made a lot in the parliamentary debate yesterday. There are some buildings of 18.1 metres tall that pose a significantly less risk to the occupants than some buildings of 15 metres tall. Suppose, for example, that you have a building of 18.1 metres tall, but it has excellent internal sprinklers, all its fire doors are compliant, and every single building that's 17.5 metres tall, where a large proportion of the residents are wheelchair users, there are no sprinklers, that's a more dangerous building. So that's on the criticism of the BSF. The BSF covers public and private sector buildings, and I want to talk about the public sector buildings a little bit later on. And the application process is, as I'm sure most of you know who've been going through this, has to be made by the building owner or the responsible entity. In practice, having looked at the delegate list today, 80% of you are managing agents. I suspect in practice, you're the people who've been making the applications on behalf of the building owner, the freeholder, or on behalf of the responsible entity, some third-party company responsible for obligations under the lease or under statute. There's a lot in the eligibility requirements, and I'm not going to go through all of them today because we could spend an hour just doing that. Despite the fact that the material for the fund says it's for 18 metres and above buildings, that isn't actually true. There's a 30 centimetre tolerance, so the top story has to be at least 17.7 metres from the ground level. Secondly, the works have to be recoverable from leaseholders. So with all of these questions, there's a case of looking at the leases to see what's recoverable. Thirdly, and this is quite a controversial eligibility requirement, the work must not have been committed to. What that meant was, if all of you remember back to post-Grenfell, the government's building owners must make their buildings safe. And do you know what? Some building owners did. And they forward funded it and then sought to recover through the service charges in due course. If your building owner did what the government told them to do and got on with remediating the works quickly, excluded from the building safety fund. There was a challenge to this. A building in Manchester called Skyline brought judicial review claim against the Secretary of State, just saying this is absurd. Our freeholder started, Skyline leaseholders say, our freeholder started the work immediately, as the government said that everyone should do. We therefore got these massive bills. The government then decided to make money available for all of those buildings where people hadn't done the right thing, and hadn't started the work already. This is absurd. Why are we being punished for the fact that we have a good freeholder? And the judicial review claim failed, unfortunately. The judge dealing with the claim said, no, I'm sorry, that's a robust decision, which is judicial code for that's quite a mean decision, but it's not unlawful. The Secretary of State's entitled to set deadlines and in set conditions. The fact that I, as a judge, may not have set this condition doesn't matter. The Secretary of State is allowed to set conditions. It might be a bit tough, it might be a bit mean, but it's his choice. It does need to be somewhat unfair. Depending upon how proactive your freeholder was, you may or may not have to pay for this money. Mixed-use buildings are okay, but non-residential isn't, although you need to be careful. Funding won't be allocated for the commercial units. The real difficulties, I think, are the last two bullet points. There is a lot of evidence required for the general but to get through the Building Safety Fund applications. And I know, again, from looking at the list, because I've talked to some of you about it, that the evidence has been painful to collect at times. The evidence requirement seems to be what's holding things up. Figures differ slightly, but there's certainly less than 10 buildings in the country that have had the money released to them yet and full awards made to them under the Building Safety Fund. And the reason seems to be delays in getting the evidence. So again, if any of you followed the debate last night, the minister, I think it was Chris Pincher in the first speech for the government, so he's one of the ministers responsible for this, he criticised managing agents and freeholders for not being able to, for not submitting all the information that was required as part of the BSF applications, and said that was one of the reasons why things have been moving so slowly. So leases weren't provided, for example, and things like that. Now, whether that's true or not, I don't know. I mean, common sense says there must be some applications that weren't submitted correctly. But if you ask for vast amounts of material, people will forget things. On the other side of the coin, I have one client who did submit everything that was required, and I know that because I helped them do it. And I have the email where it was lodged with the relevant fund manager. And then they got an email a couple of weeks back from the BSF saying, as you haven't provided the information, we're going to close your application. To which the response was, no, 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 what are you talking about? I provided this all months ago. It's not my fault. You haven't read it yet. So, I mean, I'm not entirely sure it's befitting of the minister to point the finger at industry. I suspect the reality is there have been failings on both sides. And then the last bullet point is one that I'm really interested in, but I'll touch on only briefly because at the moment we don't have enough information about it. In all under this fund, you're supposed to use your reasonable steps to pursue third parties. I'm really interested in what reasonable steps will be found to look like. In particular, are you actually going to have to sue anyone? And obviously this interests me because I sue people for a living. And if the Secretary of State is saying that he requires building owners to go around suing people, I think that's very kind of him, so as to ensure that I have enough work to do for the next couple of years. The reason I think that's, I mean, I know why it's in there. It's in there because if there is a third party who can pay, e.g. under a warranty claim or such like, then obviously it is right that they should pay and the taxpayer shouldn't be on the hook for it. But I'm really interested in what this reasonable steps is going to look like. Is the Secretary of State actually going to require you to bring litigation? Or is he going to accept that if a company has been struck off, you aren't required to restore it to the register for the purpose of suing it? Is he going to require you to bring litigation against a company that on any view can't pay any judgment you get? I mean, if it's a special purpose vehicle that did the development and it's worth £1 and it has no other property in the UK, what on earth is the point of suing it? I mean, you could, but is that a reasonable step you have to take? And I confess, I can see down the line, not immediately, but I can see in 2 to 3 years' time, situations where the Secretary of State will say, I gave you money under the Building Safety Fund. It was a condition of the fund that you took reasonable steps to pursue. I want the money back. I think that is a real possibility to watch out for in the future. And I think for most people in this call, you need to be thinking about what your reasonable steps are and making sure that you've evidenced why you did or didn't take a particular step. On the process for the BSF, registration was in June, July 2020. Applications opened in August of that year. It's a first come, first served award, as you know, which just strikes me as barking mad. Risk-based would have been much more sensible. It's posing for a minute. I really don't understand why it's first come, first served. Other jurisdictions around the world that have grappled with cladding as a problem, of which there are many, Australia being the one that's most commonly cited and the one whose legal system is closest enough to ours to mean that you can understand what they've done and work out how it would apply here. Australia, the Victoria Cladding Task Force, that they have not done first come, first served, they've done risk-based, and that seems to me to be much more sensible. And if you were to do risk-based, it would seem to me that would also give you a way of trying to reduce the worst affected Waking Watch buildings and bring down the Waking Watch costs. But as I say, the government have chosen to come, first serve. It's run by Homes England in most of England, or the GLA for London. You'll note there isn't one for Wales. Wales is apparently going to do its own thing in due course. And it's been a very, very slow process. As I said earlier, figures differ, but I haven't seen anything to suggest that we get to more than 10 buildings who've had their payouts yet. There are some provisional awards and there are some acceptances, but I don't think I've seen anything to suggest it's even as many as 10 buildings that have had the cash yet. And you can see why it's a slow process. I mean, for goodness sake, look at all this. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 stages to the application process. And some of these take a long time. I mean, on the box on the top right, I've put legal due diligence. That is not a short process. The funding decision, box in the middle on the left, that takes blooming ages to come to. Then we've got to get a grant funding agreement signed after that. And that's proved difficult because, again, I know from clients who've looked at these, some of the terms the government propose are not that attractive and they're not really interested in a negotiation about this. It's a take it or leave it approach. Then you've actually got to do the work, for goodness sake. So that's partly why it's all dragging on. What is there to flag up? Well, there's a lot missing from the Building Safety Fund, as we've flagged up already. The exclusions are quite important. mitigation measures are not included. So the alarm systems that people put in as a temporary fix aren't covered by this. Where some of the work falls under the ACM fund and some of the work falls under the BCF fund, the BSF fund, making the two funds talk to each other is surprisingly difficult. And organising it from your point of view must be quite difficult. Anecdotally, the one that I think many agents have found the most difficult to manage has been the state aid forms. It's been a requirement to try and get the leaseholders to sign declarations that they haven't received state aid in the past. And there's a real mess on state aid to do with buy-to-let landlords and whether or not, and how the state aid provisions apply to them. I really struggle with, I confess I don't really understand state aid law anyway. I would have thought one of the possibly only advantages of Brexit would have been that we could have ignored state aid laws after the 1st of January, but apparently we are still having to grapple with them. The timescales were initially very tight. When I did this talk a couple of months back, that we spent a long time talking about the timescales because everyone was worried about the fact you had to get your work started by the end of this financial year. And that was leading to a lot of design and build contracts, which it was thought weren't necessarily of the best quality or the best caliber. Timescales are slightly more extended now, so there's been a bit of pressure taken off on that. The fund is insufficient. Oh, yes, the fund is insufficient. £1 billion is not enough. Even those buildings that are getting awards, what I'm seeing is that they're only getting partial awards. You can't split £1 billion across a 15 to 18 billion pound project in a way that makes everyone even remotely happy. There are going to be huge numbers of people who either don't get enough money for this to make a difference or who don't get any money at all. And then, even if you're in the happy position of getting some money, there's a huge shortage of contractors. If any of you have been following the stories of the American American stock market shenanigans over the last couple of days, all these small-scale investors who've been buying shares in small companies or buying silver so as to try and mess with hedge funds who've been betting against these share prices. If you want to make money, don't go and mess around with the American stock market. If you want to make an absolute fortune in the next 18 months, buy a company that specializes in scaffolding, because scaffolding is such short supply at the moment that owning a scaffolding company is the license to print money. Don't bother yourself with trying to play silly games on the stock market. Just buy scaffolding. There's a huge problem, a huge shortage of contractors out there at the moment. And it's all culminating in delays to work. And for those of you who are agents managing this process, some very unhappy and uncomfortable discussions with leaseholders, I'm sure. I'll come back to this a bit later on, changes on the horizon, because we got a bit more of a hint about the government's position yesterday during the parliamentary debate. The too long didn't read summary is almost everyone thinks the government has undercapitalised the fund, and almost everyone thinks the government's response is wrong. The only people who think the government haven't undercapitalised the fund and think the government are doing a great job are the government. And there was no indication yesterday of any change in position. To the contrary, I imagine that the next development we're going to get in this will be at some stage in the foreseeable future. There's going to be an announcement about loans being made to leaseholders to help them pay for the cost of these remedial work. But we'll come back to that in a minute, because if you're following this very closely, there's a big row brewing over the fire safety bill, where a number of Tory MPs are going to use that, or try to use that, as a vehicle to get the government to put more money into the Building Safety Fund. So what's the practical implications of all the Building Safety Fund issues? The Building Safety Fund, to my mind, is actually a symptom, an element of the problem. It's not the answer. The problem is remediating, let's assume, let's take the government's position at face value. Let's assume that we only care about remediating 18 metres tall buildings. I care about remediating all of them, but let's assume that 18 metres plus is the important ones. The cost of remediating a building 18 metres tall, getting all the scaffolding to get all of the cladding off, to have a look behind the cladding, to do all the work necessary to the internal and external parts, it's multiple millions. I mean, 7 to 10 million pounds, if not more, for a building is not unrealistic. That simply can't be funded in the short term in the way the government envisages. It can't be funded by leaseholders because they don't have enough money sitting around. And where you've got a model that's predicated on the leaseholder paying for it, if you can't get 100% of the leaseholders to pay, then you can't do the work. So imagine you've got a block of 10 flats and 8 of them pay and 2 of them don't. You can't procure 80% of a cladding system. You can't leave the dangerous cladding around the 2 flats of the people who haven't paid. You've got to have enough money to do all of it. And so, to be frank, whether you get a little bit of money here and there from the fund, it's just happenstance whether or not you as managers are managing a building that's got enough money to pay for these works. It's pure happenstance whether buildings get fixed or not. But you almost certainly, as agents on behalf of the freeholders or other responsible person, you almost certainly have to apply for this fund. Unless it is absolutely dead certain that you couldn't apply, like because you're a 2-storey building. If there's any possibility that you could apply and get any money, then I think you have to. Because if you don't apply and you met the eligibility requirements, you are inviting a very, very difficult Section 19 service charge challenge down the line. A leaseholder will say with some justification, how is it reasonable to incur these costs? You could have at least tried to apply to the fund. Now, what that means in practice, it seems to me to be hard to game through. If they win on that argument, does it mean they don't pay anything? Or does it mean that the FTT would have to try and make an estimate as to what would have been awarded under the fund, and therefore reduce that element from the service charge? But for any lawyers listening, I think the question, I think it's going to be, if you didn't apply and you could have done, is what you've lost a loss of a chance, or is what you've lost an identifiable pot of money? And I think that's going to be quite a difficult question that I can see going up to the Court of Appeal at some stage. The same problem arises if you did apply, but didn't respond to requests for information from the BSF. Because the criticism is going to be, again, had you replied and had you given them the information, then they would have awarded you money. And the difficult question then is the Section 19 reduction a proportion based on the estimate of what the fund would have paid, or is it everything? So what does that mean for you in practice? I mean, I've generally been advising people that I think you have to run the project as if there is no BSF funding, because you just don't know yet. And you don't know whether you will get, it's not a binary question. It's not, I will get everything or I will get nothing. You might get nothing, you might get everything, or you might get something in the middle. You get a contribution to the costs. Far, far easier. And I think, not just easier, but I think the only way you can do it is to run it on the assumption there's no funding. But if there is funding, then credit it back. If you do that, the only thing to watch for is how you credit it back and whether you credit it back in the right way. So there's an interesting case about this called Sheffield City Council and Oliver, which is all about some grant funding that energy companies provided to local authorities to retrofit their buildings. And what Sheffield did is they applied that funding across their whole stock. And what the Court of Appeal said is, no, it's wrong. You've got to apply it to the benefit of the buildings that actually got the money. So Sheffield used it to bring down everyone's service charges. And the Court of Appeal said, no, you've got to use it to apply to bring down the service charges of the people who were designed to benefit. So the analogy here would seem to be, if a building got £1 million from the BSF, but 2 people didn't qualify on Building Safety Fund, because they were on state aid, sorry, on 1 unit didn't qualify because it was commercial, those 3 units would have to get charged their 100% share as if there was no funding, and everybody else gets the benefit of the fund. There's something else to watch out for anyone acting for housing associations, which is the Building Safety Fund monies and the ACM fund money actually seem to me to be government funds within the meaning of the directions under Section 219 of the Housing Act 1996. And what that means is, if you receive money from the BSF or from the ACM fund, then there's actually a cap on what you can charge your leaseholders if you're a housing association or a local authority. And it'll be £10,000 outside of London, £15,000 in London. And that is a heck of a big deal if you're a social landlord. That, I won't go into it now because it's quite difficult, and if there's anyone here who does social landlord work and they want to ping me an email afterwards, I'm happy to chat about it. But that looks to me like a real poison pill for social landlords, because it means that suppose you've got to do 50 grand's worth of work per flat. You get 5 grand per flat from the BSF. You're only allowed to charge in London another 15 grand per flat leaseholders, which means you've got a 30 grand shortfall per flat that by law you are now required to fund. And that is a very, very difficult situation for housing associations and local authorities to get into. Carrying on with some Section 20 issues, I've been asked a lot about this. I'm broadly relaxed about Section 20 and the Building Safety Fund. I don't see how the pre-works surveys are consultable. I accept there's no direct authority on this, but under the old consultation regulations, surveys like that wouldn't have been considered work, so I don't think they're work now. And they're almost certainly not qualifying long-term agreements because they shouldn't be for a year. The real I've generally been giving, and the view that I generally take, is I don't see how you can go for dispensation in the abstract. You've got to have a particular scheme of work to be dispensed in respect of. You can't just go and say, I would like dispensation for anything to do with cladding for the next 2 years, please. So given that you've got to have a particular scheme of work, I don't see why you can't always do, or at least almost always do, stage 1 of the consultation process. I accept that you might need dispensation from stage 2, because it might be that the terms of the funding agreement mean you have to move very quickly. But I struggle with the idea that you can just get blanket dispensation. It seems to me that it's much more likely to be a nuanced and targeted dispensation. And in any event, as I've been saying this for years and years and years, and I'll come back to it again, one of the things I would do is I'd ask the leaseholders, what do they want? Do they want there to be further consultation? Given that they're going to pay for all this if the BSF fails, then their view does seem to me to be particularly important. It can't be the decisive factor, but one of the things that people, I think, overlook with service charges quite often is that you're spending other people's money, and knowing how they think their money should be spent must always, I would have thought, be a relevant factor in deciding what you think you should do. It can't be the only factor, because they might come up with you might have one leaseholder who says something which is daft, and if you did it, the entire scheme of works would fall apart. But spending other people's money surely involves knowing what they think about how their money should be spent, and therefore consultation is a very good idea. There should be more of it. This one here, then I'll jump back because my slides are in the wrong order. In addition to the BSF, there's the Waking Watch Fund. The government published the details for that on the 31st of January, because they said they'd do it in January, so they published it on the Sunday. There's a 30 million fund available under the Waking Watch Fund, but there isn't really, because 22 million pounds of it is pre-allocated to London, Manchester, Birmingham, Leeds, Liverpool, Bristol, Newcastle and Sheffield. So there's 8 million pounds available if you don't live in those parts of the country. And despite the name of the fund, it's not about Waking Watches at all. It's about funding the upfront capital costs of particular models of alarm system. There's a standard it has to meet. And it's about using the money to try and fund that. It's good. I mean, 30 million isn't very much money. Let's be frank about this. And it's causing a lot of disquiet among leaseholders because it's the Waking Watch costs that have been so crippling for many of them. It seems to me that everything I said about the BSF applies equally to the Waking Watch Fund. If you've got a building with a Waking Watch where you've got indication that having an alarm system would bring down cost for the Waking Watch, then it seems to me you need to be applying for the Waiting Watch Fund in order to avoid a Section 19 challenge down the line. There's no, as far as I can tell, I confess I haven't read all the application material yet, so take this with a pinch of salt. But as far as I can tell, there isn't a height requirement to this one, so it looks like any building could apply to it. The real problem is 30 million quid's a drop in the ocean. Again, it's going to be a first come, first serve fund, so get your applications in as soon as humanly practical. So what's Parliament been up to in all of this? This being the second half of the talk I wanted to cover. There are two things you need to keep an eye on. The draft Building Safety Bill, which hasn't even been introduced to Parliament yet. It was published in draft last summer. It's been subject to a parliamentary committee, and it's attracted a lot of attention. And then the one that is in Parliament is the Fire Safety Bill, which is what's called ping-pong stage. It's where the House of Commons has to decide if it's going to accept the House of Lords amendments. And what's happening is the Fire Safety Bill is being used as a proxy fight for MPs who don't like things that are in the Building Safety Bill. So there are amendments in the Fire Safety Bill that are really about expressing unhappiness with the Building Safety Bill. And there's quite a big fight brewing about these at the moment, which we'll talk about. The draft Building Safety Bill came out in summer last year, and it's the first part of the considered response to Grenfell. It's about creating a new regulatory regime for higher risk buildings. I can't do the whole bill now because, again, that would take hours. The bits that I suspect you guys have paid most attention to is clauses 88 and 89. And the way those work is that they say that in all leases, whenever granted, there is an implied obligation on the landlord. It's actually the responsible person, but I'm going to say the landlord because it's easier to explain it that way. On the landlord to do the work specified by the regulator in order to make the building safe, and there's an implied duty on the leaseholders to pay for it. Effectively, what the bill is doing is it's creating a parallel service charge regime that will be the same for every lease in respect of fire, well, it's not just fire safety, in respect of building safety works. That's pretty controversial for two reasons. One, that is enshrining in law the idea that the leaseholder has to pay, including for fixing historic defects in buildings. And whether you think that's a moral position or not, I just don't think that's an effective position, because as we talked about earlier, that whole model of making leaseholder pay only works in raw economic terms if they've all got enough money for it. And it's just happenstance whether or not a leaseholder, a building has enough leaseholders in it who've got enough money to pay for this work. The other reason why it's been pretty much hated is that you have to pay the money within 28 days. So imagine, if you will, that you are the freeholder of a building and it has defective cladding, and the regulator under this new bill says, I want this defective cladding removed. You are entitled to say to your leaseholders, I've been ordered by the regulator to do, therefore obliged to pay for it. I want my £300,000 from each of you within 28 days. You only have to say that to realise how unrealistic that is going to be in many, if not all, cases. And you guys, as managing agents on this call, you're going to be having the fun and games job of trying to explain this to people. The bill got pretty much slated by the Communities and Local Government Select Committee. They had 326 submissions. Almost everyone was critical of it. They had 5 days of oral evidence in which the only people who liked it were the government. They published their report in November, and they noted that the charging system was universally hated. Leaseholders thought it was unfair. The committee thought it was unfair. And just interposing here for a minute, if any of you have been following the Grenfell inquiry evidence at the end of last year, some of the evidence coming out of the inquiry suggesting apparent dishonesty on the part of people who manufacture and sell cladding products in this country would, it seems to me, support the idea that it's universally unfair, that it's unfair for leaseholders to have to pay for this. For anybody listening, and because this is recorded, that I said apparent dishonesty, I am not accusing any individual of having engaged in anything that's unlawful, and I'm definitely not libeling anyone. We will wait to see what the Grenfell inquiry has to say, but some of the evidence is certainly surprising, shall we say, for what it revealed, or what it appeared to reveal, about the approach of the industry. The interesting bit, I thought, was what the Local Government Association said, because the Local Government Association said that the charging provisions were the biggest shortcoming in the bill. And the Local Government Association will benefit massively from clauses 88 and 89, because the Local Government Association is local authorities. Local authorities have quite a lot of leaseholders across the country under right-to-buy schemes. Right-to-buy leases are generally not very well written. They don't, for example, as a general rule, not an invariable rule, but as a general rule, you can't recover the cost of improvements under right-to-buy leases. And lots of these works will be improvements, which means that local authorities will have to pick up the cost of it themselves. So the local authorities would benefit massively from something like set clauses 88 and 89, and their representative body says that clauses 88 and 89 are the greatest shortcoming in the bill. The committee noted that previous governments and the current government had said that leaseholders should pay for fire safety works, and noted with concern that they've been backing away from that recently. And the committee asked really for two things. The first two bullet points are their big ask. Basically, government forward fund it. Just fund all of this to make these works. And there's a range of different views on how you get the money back. I tend to the view that a tax on developers is the way forward. That's what the Australians have done. But how you get the money back strikes me, frankly, as a lot less important than making sure that people don't burn to death. The small ask from the committee is, if you're going to do this, you've got to give people a lot longer than 28 days to pay. It remains to be seen which of those two suggestions the government will adopt. I suspect they will adopt the little ask rather than the big ask. So, where are we at the moment in terms of developments on fire safety? There is cross-party opposition to charges falling on leaseholders, and we'll come to this in a minute when we look at the amendments in the fire safety bill. The government, perhaps to my surprise, seems surprised by how unpopular their proposals have been. And they're currently leaking generally to the Sunday Times that their proposal is to help fund these works, not by upfront money from government to pay for it and then recouping, but by 30-year loans at 2% interest to help leaseholders pay for these works. Now, the devil's going to be in the detail, and we haven't seen any detail yet. To be fair to the minister, he did say there'd be more detail coming shortly. But it looks like the way it would work is the government would loan the freeholder the money to do these remedial works and give the freeholder of that loan and pass it on to the government over 30 years by way of an additional charge to the leaseholder each month. Basically, the freeholder acting as a kind of mortgage provider for these bits. It isn't really, because it's the government's money, not the freeholder's money. The freeholder acting as an intermediate body for this. That's going to be, if that is what ends up happening, a lot. I can see freeholders wanting, with some justification, to be able to charge their own administrative and internal fees of running that process, because that isn't going to be easy. And what you do about default will be the critical bit. Because are we going to expect freeholders to forfeit for non-payment of this money? If we are freeholders prepared for the bad publicity that will come with that? And what do you do about situations where the person with the loan isn't the freeholder, say an RMC under the lease, and therefore they can't forfeit? The devil was going to be in the detail, and we need to see where that comes from. But that is the extent of the government's thinking at the moment. It does not look like there'll be more money coming forward. So let's look at the fire safety bill then for the last couple of minutes. Fire safety bill does two relatively simple things. It fixes two anomalies in the regulatory reform fire safety order. So that's supposed to be the main statutory vehicle by which you enforce fire safety in this country. And what it's going to do is it's going to expressly bring cladding and the front doors of flats, regardless of who owns them, into the scope of the fire safety order. And that's quite a good thing, because cladding is currently not part of the fire safety order, and the front doors of flats, the position is very messy about whether or not they're covered by the regulatory reform order or not. I can argue that they are and they are not, depending upon what you want the answer to be. The controversial bit is about who's going to pay for it. So in the Lords, a Lib Dem peer added an amendment to the fire safety bill, the effect of which was in those two sections there, that whenever you do any work as a result of the fire safety bill, So as a result of the regulatory reform order, that means you can't charge leaseholders for it. It's not a very good amendment, because one of the things it would do, for example, is it would prevent you recharging for the annual fire safety check, which is not what's intended. We know what's intended. It's trying to make a political point that leaseholders shouldn't have to pay to fix dangerous cladding on their buildings. There are different amendments down at the moment when this comes back to the House of Commons. There's an amendment from 2 Tory MPs, which has attracted a lot of support from both the Conservative benches and the Labour benches, which would, if that were adopted, it would say that you couldn't charge leaseholders service charges for the costs of remedying problems which need to be remedied because of the fire safety order and which arose before the leases were granted. There's another amendment from Labour, which is very, very similar, which does almost the same thing, but says you can't charge for it regardless of when the problem arose. So you couldn't charge for a refurb if the Labour one was adopted, if the refurb ended up being... Those are the 2 competing amendments going forward at Parliament about all of these. One of the 2 MPs on the Tory side who put forward the amendment to indicate he'd had very productive discussions with the government. And what I took from that is the government were open to buying off his amendment. The Tory MPs who spoke, now what buying off might look like, we don't know, and no one gave us any clue on that. Whether it's a slightly more generous loan system, whether it's some more money in the BSF, I don't know. The other Tory MP who's leading the rebellion had said nothing like that at all, but one of them indicated that he'd been in discussions with the government, and that's what I took from it. There's no support on the Tory side for the Labour amendment at all. And in order for either of these amendments to pass, you're going to need, I think it's 73 Tory rebels. It's not 40, as lots of people seem to think, because this is an English votes for English laws issue. So the Scots Nats don't get a vote. So the majority, because you ignore the Scots Nats and you ignore the Northern Irish as well. Prospect of either of these amendments passing. I think there is more, I thought there was more prospect of the government buying them off. But the government ministers in the debate last night, both at the beginning and the end, gave absolutely no hint that they're interested in buying this off. They appear to be putting all of their eggs in the loan basket, and we will see where they come back with in the future. I don't think there will be enough MPs willing to rebel on the government side to get either amendment through. I think it is really a question of what, if any, deal can be done, but remains to be seen. I suspect the next announcement we get probably be in March when the Chancellor does the budget. I imagine that's the earliest we're going to hear anything about the Building Safety Fund and whether it's loans or further money. Now, that brings me to the end of my talk, and I have been talking for 50 minutes, which, given that I said I would talk for 30 to 40 minutes, is actually not bad by Barrister standards. So let me see what questions have come in, and let's try and pick some of this here. Anonymous attendee, which is a rather unfortunate name that your parents granted you, asks, how would the loan work with people selling? Would the loan sit with the property unit rather than the owner? Your guess is as good as mine, because until we see the details of the loan scheme, we don't know. But yes, I think that's how it would have to work. And that just gives another problem down the line, because the people who are selling normally want the equity from their flat to go somewhere else to help them buy a bigger problem. And it's going to eat into the equity. Because if I'm buying a flat subject to a 25-year charge that I've got to repay, I'm going to want that reflected in what I pay you for the flat, because I'm buying an encumbered flat. I might like it, I might still buy it, but I'm not going to give you full unencumbered market value for it. Why would I? And I can see that being the problem with the loans. Will the Building Safety Bill cover the replacement of flat front doors? So we don't know is the answer. The way the Building Safety Bill works will be, it doesn't really tell us what the regulations are yet. So we'd have to see what the regulator wants to do. The Fire Safety Bill will help with the flat door position, because of what that's going to do if it's enacted is the uncontroversial bit that everybody agrees should go through is it will say that front doors are within the scope of the regulatory reform order, which means that you as freeholders or managing agents who've got duties for the common parts of the building, but powers to do things to the front doors of the flat, even if the leaseholder owns the front door of the flat under the terms of the lease. I don't want to get too detailed. You do, it will depend on what your lease says in each case, but it's going to make life easier for you as regards the front doors of flats. Do I think the government will include developments that are below 18 metres? No. They gave absolutely no hint about that yesterday. They seem to be conflating 18 metres with a risk-based approach, which is just nonsense. And the problem for the government is once you bring in the sub 18 metre blocks, that makes it absolutely clear that 1 billion in the BSF isn't enough. So I'm afraid I think they're going to ignore it. Should you apply to the fund even if the building is lower than 18 metres? I think it depends how much lower, is the honest answer. If your building is 5 metres, no. If your building is 17 metres and 69 centimetres, I would have been tempted to apply. I know the rules say 17 metres and 70, but you and I both know that different surveyors can find slightly different ways of measuring to get us to the right level. It's the grey area buildings where I think you get nervous about it. Who is the right party to lead the application process? As it appears, two specialists for a managing agent, legal advisor or a specialist. I think it depends, is the honest answer. Because that isn't fair, but they are generally the bigger managing agents who have access to the broader support services and can buy in additional skills they need. If I were a small managing agent company, maybe do a couple of hundred, maybe a couple of thousand units, geographically limited, I would be pretty nervous about leading on the fund. I certainly also wouldn't be leading on the fund without having checked the terms of my professional indemnity insurance. I wouldn't get a lawyer to do it, actually, because it's not really a legal issue. I'm aware of their legal department are helping to oversee it, but that's different from having a lawyer lead it. This is a horrible management consultancy phrase, but it is a multidisciplinary, multi-skilled process. I'd be surprised if anyone has got just one person leading on it. For what it's worth, I imagine that I imagine that in a small to medium-sized company, it's really the leader of the company who's got to take responsibility for it, and he or she is going to have to make sure they allocate tasks responsibly and buy in skills where needed. Because getting this wrong is potentially very, very, very risky. What else have we got? Oh, more questions are turning up. It's because I answered them in the wrong order. That would be why. That would be why they turned up at the end. Right. What have we got there? So I've answered that one. 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 Let's get rid of it. I'm going to get rid of that one. Fund. The ACM fund's closed now, I think. I don't even know if they're accepting applications any further. I don't think so. I think ACM has been and gone, I'm afraid. If we apply to the BSF but don't hear at a reasonable time and clients want to proceed and can afford to pay, are they still open for a Section 19 claim? Yeah, you're always open to a Section 19 challenge. I can't protect you as a freeholder against being sued under Section 19. That's just not possible. If a leaseholder wants to challenge you, they can challenge you. I think if you were challenged and you had an outstanding claim open, I'd be saying to the tribunal, you should surely adjourn this application until we know what the fund's position is. And I think the tribunal would probably agree to that. And challenging you, that's just not possible. Picks up any shortfall? Well, here is the multi-million-dollar question, isn't it? The way, as I understand it, the way it will go is like this. Imagine that I am the freeholder of a building and I've got cladding that I've got to replace. The contract is going to be between Justin Bates, or Justin Bates Limited if I've done it through a company, as the owner of the building, and Joe Bloggs Cladding, or Joe Bloggs Cladding Limited. If I don't pay Joe Bloggs Cladding, Joe Bloggs is going to sue me, so I'm going to have to pay. If the leaseholders don't pay, that my contractor doesn't care where the money comes from, and my contractor is entitled not to care. My contractor says, I have a contract with you, Justin. You promised to pay me 3 million quid. You haven't paid me 3 million quid. Give it to me or I will sue you. Whether I can recover it from anybody else isn't his problem. And that's the real difficulty with this. Because for many freeholders or third-party management companies, they just can't responsibly let the contracts until they know they're going to get the money. Because if they don't get the money from the leaseholders, then how are they going to afford to pay for it? And that is why, ultimately, I think it can only be central government funding in the first instance. I mean, if needs be, a guarantee rather than central government, rather than actually funding it up front. But central government is the only body that's got the money to do this up front. It has to be central government, and then we'll deal with how you recover it later. Can you clarify the Waking Watch Fund? Is the fund not covering Waking Watch? No, despite the name, it's not covering your Waking Watch costs. It's designed to help you fund an alarm system so as to bring down the Waking Watch costs. You cannot take your historic Waking Watch cost bills and give them to the fund. You will not get them reimbursed. Waking Watch cost name is misleading. It's really a fire alarm fund. Do you consider that long leaseholders, essentially innocent bystanders who've been dragged into a horrendous situation that's been caused by road contractors, building inspectors, and a whole other group of others, including landlords, funds and others who have allowed this to happen? Why should lessees therefore be called upon to pay as a matter of equity? I think we have two things. A, no one in their right mind should care what I think about how I got into this situation, because that's not legal advice. But two, I think there has been a 30-year systemic failure of regulation in this country, going back to at least in this country. I think the rise of the improved inspector regime has proved to be a complete disaster, and I think the loss of skills in the local authority inspection regime as a result has also proved to be a disaster. I think there is pretty strong evidence that we have a very poor building culture in this country. Perhaps where we differ companies slightly is I'm not saying who are the problem. Many landlords purchased their freehold reversions and played with no role at all in the building of it. So to give you an example, I act for some very large public sector pension funds who own lots of buildings in lots of our big cities, and they buy those because they want the ground rent, because the ground rent is an incredibly secure form of investment for a pension fund, and that makes life a lot easier for them. I struggle to see why a pension fund that exists to pay the pensions of teachers and cleaners is at fault for this. It's just bought an investment. Grenfell Inquiry Module 6 is going to look at who's responsible. The answer is, it seems to me, going to be a mixture of the government and the construction industry. Important. Sorry, I know other questions coming up. Having said you shouldn't ask lawyers about this stuff, I think this is really less important. Blame comes later. What matters at the moment is we have anywhere up to 11 million people who are living in buildings that might burn down and kill them. Just fix the damn buildings, and then we'll worry about whose fault it is later. And the only people that can fix the building, because of the money involved, is central government. Is the fund only covering alarm situation after 17th of December? Yes, it is. What about installations before that? You're on your own, sorry. Can the BSF pay for internal file compartmentation work? Rules for ages. I can't remember is the honest answer. Late AC. Oh, Charmaine McQueen McQueen Prince has replied to say late ACM applications may well be considered, but the responsible entity might be named and shamed for being out of time. It's highly likely that a number of buildings have been missed. So there you go. Apparently late applications can be considered to the ACM fund, or they query how much money is left in the ACM fund. So on the face of it, apply. The worst they can say is no.
I have. Do you want to finish? Any last questions? Are you done? You've done the whole
I've actually answered all of them.
Good effort.
I know.
Fabulous. Fabulous. Well, thank you so much for your excellent session. It's definitely very thought-provoking. And I hope everyone has gained something from it. I know I have, actually. You know, I hope we will be able to entice you back again for another session sometime.
At some stage, yeah. I mean, let's see what we get. This is an area where things are going to change. They're going to change a couple of times throughout the course of the year. I would have thought. There will be another announcement about funding at some stage soon, because the government told us that yesterday. I reckon it'll be in the budget, which means March. By the end of the year, you're going to start to see awards having been made, and I suspect litigation started, where buildings didn't get as much money as they were expecting. I wouldn't be surprised if you don't want to do another one of these middle. I would have thought. Well,
hey, you'll be on the phone.
Whether you want me to do it or not doesn't matter. I may have so totally depressed everyone that you want someone more cheerful to do it.
Sadly, we're not full of cheer at the moment. I don't think anyone is, but we're all trying our best. But I have to say, thank you so much. It's been really helpful. And we do hope that you'll all join us again. We've got another session next week when James Paul from Earl Kendrick is going to be talking about insurance reinstatement and cost assessment. So if you'd like to come same time next week, hopefully that might be a little bit more joyous. Who knows? Who knows? But thank you very much. And Justin, it was lovely to see you today. So thank you very much.
And you. Nice to catch up.
Thank you. Lovely to catch up. Bye-bye.
Cheers, everyone. Bye-bye.
Bye-bye.